Have you ever wondered about the financial road ahead for your loved ones after you are gone, especially regarding the costs involved in managing your estate? It is a common concern, and understanding these details can bring immense peace of mind. When comparing will and trust administration fees, the core difference lies in their respective processes. Wills typically go through probate, which incurs court and attorney fees, while trusts generally avoid probate but involve ongoing trustee administration costs. Therefore, a will's administration costs often come upfront during probate, while a trust's costs are usually spread out over time and can vary significantly. The primary reason for this difference stems from the legal mechanisms each document employs. A will, to transfer assets, must be validated by a court through a process called probate. This public process can involve attorney fees, executor fees, court filing fees, and appraisal costs, which are often calculated as a percentage of the estate's value or on an hourly basis. A trust, on the other hand, holds assets during your lifetime and, upon your passing, allows a designated trustee to distribute those assets privately, outside of court. The costs here primarily involve trustee fees, which can be a flat fee, an hourly rate, or a percentage of the trust assets managed annually, along with potential accounting and legal fees. To better understand what this means for you, consider a few key factors. If you opt for a will, research the average probate costs in your state, as these can vary widely. Ask potential attorneys about their fee structures. Do they charge an hourly rate, a flat fee, or a percentage of the estate? For a trust, inquire about the proposed trustee fees, especially if you plan to appoint a professional or corporate trustee. Understand how often these fees are charged and what services are included. Always request a clear breakdown of all potential costs upfront, whether you choose a will or a trust. An important insider detail is that probate records are public, meaning anyone can access information about your estate and beneficiaries. Trusts, by contrast, offer a significant advantage in privacy, as their administration typically remains confidential. Also, the complexity of your estate plays a huge role. Estates with many different types of assets or beneficiaries will naturally incur more administrative work and thus higher fees, regardless of the document used. Moreover, the efficiency of your chosen executor or trustee can directly impact costs, as a well-organized administrator can streamline the process and potentially reduce expenses. Ultimately, the choice between a will and a trust involves balancing initial setup costs, ongoing administration fees, and considerations like privacy, complexity, and how quickly you want assets distributed. Understanding these distinctions empowers you to make an informed decision that aligns with your wishes and provides the most efficient and cost-effective outcome for your beneficiaries.